The level at which an assault is charged is largely going to be dependent upon the level of damage that was incurred. For instance, if you break bones, if you cut flesh, if you severely beat someone, it can go all the way up to the first degree felony level. That's serious bodily injury. It's a 5 to 99. They have to prove all of the normal things that they would for a first degree assault charge, but the state will also have to prove the nature of that relationship, and if they do, there are going to be some consequences going forward. The other thing that you need to keep in mind with assault family violence is that if an agreement is made regarding probation, there will be some additional classes that the probationer will have to take. Very often, even when we're talking about simple misdemeanor assault family violence, that's going to result in the defendant taking at the very least a BIP class, which is battery, intervention, prevention, and protection. It's a class designed essentially to teach the defendant this is not how we settle arguments with our loved ones. Some of these classes can be online. A lot of them are in person. It's going to depend on what the state wants. Sometimes maybe if you're having some issues with the complainant showing up, you might be able to work out a pretrial intervention because the state can't really prove that this happened without the spouse wanting to, or significant other wanting to testify. And you might be able to work out, hey, take a BIP class, take a couple other classes, and then we'll dismiss it. That's not an uncommon result. But if you do take probation, there's going to be some kind of class related to that at the end of it. So just be aware that it's not going to, if you're in a normal assault probation, you're less likely to have to take some of these classes. But if it's a family violence, they're definitely going to want to put those kind of restrictions and requirements on you as part of your probation. Now, while assault family violence can also cover what is essentially child abuse, meaning that an assault against a child of which you have a blood relationship or a marital relationship, not married to, but say it's your stepchild, that can cover that, but most often that is going to fall under what we call injury to a child, okay? And injury to a child covers a lot of the same things, but it has a couple of exceptions that make it a little bit different from a assault, family violence, or even a regular assault. First thing that you need to be aware of is that under a injury to a child, you can also be charged by omission. For instance, let's say we've got two parents, they're spouses. They live in the home with their child. One of them is abusive to that child. The other one loves the child, does nothing wrong to the child, but doesn't either stop the abuse or take the child to the hospital to get medical care because of the actions of the other spouse. With omission, the state has to prove that you essentially allowed that to happen and you did not seek that medical attention even though you knew you should have, okay? And this one can be very tricky because, sometimes you've got instances where one parent is abusing a child, but the other parent doesn't really know. And it's very difficult to prove a negative. And that's just normal, how things work from a logical standpoint. I can prove that you knew something because I can show what you should have been aware of, what evidence was there in front of you that should have caused it to click in your mind that an action needed to be taken. What I can't prove is that you actually noticed those things, okay? And so that makes it very hard to show that you failed in a duty sometimes. But the state gets to rely on the fact that once they've charged you, you're looking at punishment, and if they take you to trial, juries don't usually like things that have happened to small children. That tends to make them upset. That's why this is its own charge to begin with, is because hurting a child makes a lot of people very unhappy. And we don't see as a society that is something that is included in your duties to your children. So you've got to be careful if you get charged by omission. But as far as intentional injury to a child, it follows a very similar structure to some of the assaults. It can start off at a state jail felony and work its way all the way up to a first-degree felony, depending on the level of injury to the child that occurred. For instance, serious bodily injury will be a first-degree felony. Attempted injury to a child, which means maybe you look like you were about to do something to the child, but you didn't actually do it, someone stopped you, something of that nature, that's a state jail felony. But, keep in mind, state jail felony is 6 months to 2 years in a state jail facility. It's still not a lesser crime. It's definitely not a misdemeanor, okay? All of these will result in issues with your gun ownership, even if there's no specific finding of family violence. And you have to be very careful, because it's hard to get these things sealed, because they're likely to have a finding of family violence, which will make it very difficult for you to get jobs, especially if part of that job is the care and monitoring of children. People are not really going to be enthusiastic about someone with that kind of a history being around children. And so those are our basic family violence crimes. There can be a lot of individual detail, but like I said, with the assault, we will cover assault in a different video, and we'll go through that. Just understand that it's going to follow that structure, but there's going to be some additional caveats if they put on their assault family violence as opposed to just assault.